I'm telling you that the work that we have, if you're concerned about the Trayvon Martin case or Juror B37 or racism or all these other things, the immediate work that we have to do is to unmask and expose the role of the National Rifle Association and Wayne Little Peter, their $2 million a year spokesman, Wayne LaPierre, and Jeb Bush, the governor of Florida at the time in 2006, the Stand Your Ground law was passed, and point out that under this Stand Your Ground law, frankly, and I don't get it, why, the more I think about this, the more I'm astounded by it. Here's, Florida law used to say, These used to be the jury instructions that were given in a murder case, in a capital case in Florida, prior to Jeb Bush pushing through and signing the Stand Your Ground law in 2006, the ALEC NRA Stand Your Ground law. Stand your ground and shoot first is what it should be called. The Stand Your Ground and shoot first laws. The jury instructions used to be: the defendant cannot justify the use of force likely to cause death or great bodily harm unless he has used every reasonable means within his power and consistent with his own safety to avoid the danger before resorting to that force. Now, that's the standard. I would submit to you that both the defense in this case and, frankly, the prosecution and virtually all of the media and all of these, particularly white folks who are calling in defending George Zimmerman, that is the standard to which they are holding Trayvon Martin. That he had no right to punch George Zimmerman in the nose or beat his head against the deadly weapon of the sidewalk. He had no right to do that unless first he had tried everything else, every other way to resolve that conflict, including fleeing. That's the standard to which they are holding Trayvon Martin. The old pre-2006, pre-Jeb Bush, pre-NRA, pre-ALEC, pre-Koch brothers law. That's the standard to which they're holding them. They're holding Trayvon Martin. The law continues. The jury instructions continue. And again, this is the standard to which they're holding Trayvon Martin. They're saying he did not have the right to punch out George Zimmerman. He should have been running home. In fact, as I was reading to you from Bill Keller's piece, Bill Keller says, the facts were, and I quote, the facts were clear that Trayvon Martin had more than enough time to get back to his father's house, but chose instead to confront Zimmerman, break his nose, and continue the violent attack. So the standard that they are holding Martin to is that he did not have the right to stand his ground, that he should have run when confronted with the possibility of violence. And in fact, the old law, pre-ALEC, Koch brothers, 2006, NRA, Stand Your Ground and Shoot First law, not only said the defendant cannot justify the use of force likely to cause death or great bodily harm unless he has used every reasonable means within his force and consistent with his own safety to avoid the danger before resorting to that force. But it goes on to say the fact that the defendant was wrongfully attacked, and Trayvon Martin was certainly wrongfully attacked. He was just walking home with Skittles and iced tea. The fact that the defendant was wrongfully attacked cannot justify his use of force likely to cause death or great bodily harm if, by retreating, he could have avoided the need to use that force. That is the old law. That is the standard to which these people want to hold Trayvon Martin. Is that not clear? Does everybody not get that? I mean, Bill Keller laid it out so clearly. This is the standard for Trayvon Martin. He had time to run home. Let's sit for 4 minutes, the defense said in the courtroom. In those 4 minutes, he could have run home. Instead, he chose to beat up our client, the defendant, Mr. Zimmerman. And see, under the old law, The fact that the defendant was wrongfully attacked cannot justify his use of force likely to cause death or great bodily harm if by retreating he could have avoided the need to use that force. You get this? Trayvon Martin was put on trial by the defense in this case using the pre-2006, Koch brothers. I had Danny Goldberg on my show last night, and he kept calling them the Koch brothers all night long. It's stuck in my head. Pre-Koch brothers, pre-NRA, pre-ALEC, pre-stand your ground and shoot first law. Okay, this is the standard prior to 2006. That is the legal basis under which they tried Trayvon Martin both in the courtroom and in the press. Now, they used a completely different standard to try George Zimmerman. They used the post-2006, post-Koch brothers, post-NRA, post-ALEC, post-stand your ground and shoot first law. And here are the jury instructions that were given by Judge Nelson to the jury as a result of the stand your ground law. If George Zimmerman was not engaged in an unlawful activity and was attacked in any place where he had a right to be, he had no duty to retreat, and he had the right to stand his ground and meet force with force, including deadly force. You get this? George Zimmerman had that right. But nobody ever said, if Trayvon Martin was not engaged in an unlawful activity and was attacked in any place where he had a right to be, he had no duty to retreat and had the right to stand his ground and meet force with force. Nobody ever said that, at least to the best of my knowledge. Now, I did not watch every minute of the trial, but it sure seems to me like Trayvon Martin was tried in this case under the pre-Koch brothers law, the pre-stand your ground and shoot first law. And George Zimmerman was tried under the post-stand your ground and shoot first law. Is this starting to get clear? Is this starting to make sense? Are you starting to get a handle on this?
You're listening to the Thom Hartmann Program. Call 866-987-THOM.
That is the essence of the subtlety of the racism played out in this case that nobody's even pointing out or talking about.